This is an appeal in the matter of children.
Yes, Mr. Gresham.
Lords, I appear with Ms Baker on behalf of the appellant mother in this matter. My learned friend, Mr Tyler, King's Counsel, appears with Ms Amaraf-Tarbi on behalf of the father.
Yes.
The mother is present in court but sat at the back so as to be off the screen for the purposes of the live stream. This is an appeal, as you know, of a decision made by Ms Markham, King's Counsel, to return parties to children, who we've referred to as D and G, to Nigeria, following...
Well, for formal purposes, I'll just reiterate that as this is a case concerning children, neither the children nor their family is to be identified in any report of the proceedings.
Indeed. Well, I'm grateful for that. As I was saying, this is an appeal of the decision to return the subject children D and G to Nigeria on the father's application that was made under the inherent jurisdiction in Form C66, determined by Ms Markham following two aborted final hearings, one that was adjourned without attendance in November, and the second that was adjourned as a consequence of difficulties with the mother's representation in December. The hearing having eventually concluded in January with the making of an order for return that it might be thought somewhat confusingly is dated the 4th of February.
Could we walk through this with you, because we were trying
Yes.
to work it out ourselves. So the hearing eventually took place on 27, 28, 29 January. And I know that only Ms Amaraf-Tarbi will have been there, but what exactly happened on the 4th of February? Was that submissions day, or did anything else happen?
Mr Tyler may be able to provide more of an answer.
Yes.
There is a further confusion in the return order. Because
Well, before we get to the return order, let's just work out who was where when.
The mother's evidence was concluded on the 4th of February.
Right, so there was evidence over the 4 days.
And submissions then were received in writing and not then orally spoken to.
Right, and so the judgment is dated the 20th of February, that being the date of its having been handed down. No, right, it says it was handed down on the 20th of February. It's part of the return order. So could we clarify then what happened with the judgment after written submissions?
Sorry, it was distributed on the 14th. It was handed down on the 20th. The judgment was distributed in draft on the 14th of February.
Right.
And then it was handed down on the 20th.
Right, so from the 14th of February, the parties were aware of the judge's decision, but it took some time to obviously hand down the formal judgment and to create the order. So I'll come back, if I may, to Mr. Gresham then. So where we see that she had been sitting on those particular days, that's correct. And then the date of the order itself, what date does the order itself bear? It bears the 4th of February, which is not correct.
Which is not correct. And then one can see at page 82 of your core bundle an order that was made subsequently on the 25th of February.
Yes.
Making provision for the release of passports, but that says at paragraph 3 on page 82 that the order providing for summary return of the children to Nigeria was in fact made on the 21st of February.
Right, well, I don't suppose it makes a great deal of difference, but it would be helpful at least to know what the date of the order that you're appealing against is. So is there any advance on the 21st of February?
My understanding is the 21st is the date on which the order was approved, and the 4th of February is probably wrongly on it simply because of the convention that it's the last day of the hearing, which often is recorded as the day of the order, regardless of how long it's
Well, what we've got then at page 80 is an order which wrongly bears the date the 4th of February, we should treat that as being the 21st of February, and it's sealed on the 26th of February. And then, Mr. Gratian, you were then coming on to deal with the effect of the order, which was for a sequence of events to take place whereby the mother would give notice of her intentions, and the return order was effective on the 1st of March.
Effective on the 1st of March if return was to be with the father, the 7th of March if the mother indicated her intention to return with the children.
Thank you.
In the alternative. But albeit this may be a matter of sequence rather than anything else, the starting point of the order is return with the father by the earlier date.
So that's paragraph 15.
Yes.
Well, the order really isn't in a very good shape, is it? Because if you look at paragraph 15 on page 78, I'm seeing that it's said to be subject to the provisions of paragraph 15 below.
Indeed.
Should that be paragraph 17?
Yes.
Right, so 15, paragraph 15 is return with father, but at the mother's election, she can return with the children 6 days later, paragraph 17.
Yes.
And she only had until 4 o'clock on the day of the approval of the order to make her decision.
Indeed. Right. And she did not notify.
She made no election. So untweaked, the effect of the order was for a return on the 1st of March.
Yes.
With the father.
Indeed.
Thank you.
The mother, upon receipt of that, and you've seen that she says, and the father does not accept, that she had late notice of the decision, did not receive the judgment in good time, but when she did, she changed her representation, and her appellant's notice was then lodged by her current solicitor's International Family Law Group, together with an application for a stay. That stay was in due course granted, and Lord Justice Moylan then granted the mother permission to appeal on the 5 grounds that she advanced. Just because there has been some confusion for which we take the blame and apologise in relation to the bundles that were filed for the purposes of this hearing, I just wanted to make sure before I go further that you all have the benefit, if it can properly be described as such, of a core bundle, a supplementary bundle, and after the inquiry made yesterday, a bundle of the case management orders. We have submitted alongside that a chronology of the case management, which in fact we were preparing at a time when you didn't have those orders. It has been to an extent, I suppose, superseded, forgive me, by you having the bundle, but we thought it was helpful to provide it nonetheless because it sets out on our case some of the, if they can be described as such, challenges of case management that arose here in part as a consequence of the father's changing case over time, because of course it is one of the features of this case that it began as what might be described as a straightforward application for summary return to Nigeria, but the father's case developed firstly with an in the alternative application for return to Saudi Arabia, but then in due course when he filed his evidence, an application for what can only be described as a relocation of the children to Bahrain, a country in which they had never lived and with which they had no connection at all. So that was a feature of the case as it developed. There does not seem to have been, and I'll come on to develop this in due course, any actual impact on case management of the father's changed case in that regard. His evidence gives a detailed proposal for the children to relocate to Bahrain, but nothing seems to have been done about it. And in fact, that aspect of his case does not find mention at all in the judgment that was made granting the application for return to Nigeria. That gives rise, we submit, to part of the overarching problem that arose in this case, or at the least demonstrates the effect of it, which is that this being an application advanced in straightforward terms for the return of these children to Nigeria, it engaged in a straightforward and obvious way the principles established by the House of Lords in Re J, and by way of development of those principles, the 8 linked questions, as he described them, that were expressed by Lord Wilson in Re NY. Those principles arose and should have been considered, we say, throughout this case, in the case management process, but also, and perhaps particularly, at the pre-trial review stage and at the final hearing, because they identify and allow proper focus on the things that the court has to decide when dealing with an application for summary return. If we submit, a judge at case management stage, but perhaps particularly because this hearing had the important consequence of setting the shape of the final hearing at the pre-trial review on the 4th of December, the judge had turned her mind to those principles. She would, we suggest, have considered and defined the particular type of order that she was being asked to make. Was she being asked to order summary return to Nigeria? If so, was that on what I'll describe as the classic basis, that it was a return with the taking parent for the purposes of litigation in that country? Or was it something different? For example, was it return with the father, with the mother staying behind, as she had said she would? And if so, what was the impact of that? What factors was the court required to consider in order properly to determine those issues? Would it be necessary, depending on the type of order sought, for example, to determine the allegations of domestic abuse? And if this was a return for litigation to a country that would consider and determine those allegations and give proper protection to an alleged victim of domestic violence, it might not be necessary to reach factual findings. If in fact it was a return to a country, as some countries that are involved in non-Hague inherent jurisdiction cases are, where they would not determine allegations of domestic abuse, it almost certainly would be. What was the legal process in the country of return? Would it permit an application for relocation? All of those things would have come to mind, and the court would have case managed them and dealt with them. But unfortunately, it does not seem as though at any of the case management stages here, these points were considered. And that becomes particularly apparent, we submit, when one comes to the order made at pre-trial review on the 4th of December. And that order is in the bundle of case management orders at page 34. And albeit I'll deal with this in a little more detail later, it might be helpful to turn it up now, just so that we can see what was dealt with at that stage. So we have the order, which begins at page 29. That sets the 2 hearings that the judge had before her, the, in the end, abortive hearing on the 16th of December, and then the subsequent 2-day hearing on the 27th of January. It makes various other directions, but the most significant part for this purpose, we submit, is within the recitals, which, for reasons I'm not entirely sure about, appear following a subsequent disclosure order, so are at page 36. And particularly the recital on page 36, paragraph 3. And the judge there sets out what she is intending to determine at the final hearing on the 16th of December and gives a menu of issues. The first being the children's habitual residence, but that does not form any part of the issues or matters identified by Baroness Hale in Re J as requiring of determination. In fact, as we'll come to see within that case, she, Baroness Hale, draws a deliberate distinction between the technical concept of habitual residence and what she says is relevant, which is where the children's home country is. B, whether the children were wrongfully removed from Nigeria is no part of an inherent jurisdiction inquiry. It's simply an irrelevant factor. It is, as my lords will appreciate, a 1980 Hague Convention concept. But of course, one of the key principles in Re J was a determination to avoid eliding principles from the 1980 Hague Convention with inherent jurisdiction return cases. C, the applicant's allegations about the respondent's capacity to care for the children may be relevant in the context of a custody decision, if what we're looking at here is whether the children should be living with the mother or with the father. It's quite difficult to see how it fits into an application for summary return on the basis that there will be litigation in Nigeria, because presumably in that context the courts there would be making that decision. But it finds its way into this menu, and then as a separate and distinct category from C, and only to the extent that the court determines it is necessary, the allegations made by the mother, which fall into this separate category for reasons that are not explained. So, my lords, in our overarching submission, and we've developed this through the grounds of appeal that we've advanced, what this demonstrates is a failure at all stages really of this case, but then particularly at the key stage of planning the trial on the 4th of December, which then filters through into the trial itself, to identify and to apply the key principles that the court is actually required to apply in this context.
Was this part of the order contentious?
My lord, I don't know, I'm afraid. There is no description as to how it arises. It finds its way through into both the cost judgment and the final judgment, without explanation as to why, for example, the judge considered it necessary to resolve habitual residence and wrongful removal.
I suppose at least in the judgment under review, at paragraph 4, when she reproduces those 4 points, she does at least add then E.
Well, yes.
The best interests of the children.
My lord is ahead of me in that regard, because that actually is the only real principle that the court had to address and deal with here, albeit it's part of our case that how the court goes about doing that depends on the context, and particularly what the court is being asked to do. But that is the key guiding principle, and yet when the court case manages this case, it doesn't find its way into the list. It is only when it comes to the judgment that it is added, and then at the end. But, my lord, in our submission, the fact that it's added to the list does not, in fact, save the exercise, because when one looks, as we'll come on to through the lens of the grounds that we advance at the actual judgment, there are key aspects of the welfare inquiry that the judge simply doesn't address. Most particularly in the light of the mother's position, there is no mention at all of the impact on these children of separation from her, notwithstanding that it appears to be accepted on all of the evidence that for the great majority of the children's lives, she was their sole carer while the father worked abroad.
The difficulty you have with that submission is that the judge didn't accept that there would be separation. I think it may help if I appreciate you're doing your overarching
Yes.
submission here, and we well understand it. But there are two strands to the grounds of appeal. One is what you've been dealing with so far, which is the error under ground 1 in importing convention concepts. And ground 4 then deals with the welfare issues that you're
Yes.
also talking about. And those are clearly, as you've described them, somewhat interlinked. And we'll want to understand whether what at the moment, speaking for myself, is a clear error in relation to these identification of issues and self-directions actually made any difference.
Yes.
Because, you know, it's not a law exam. If they didn't make any difference, they didn't make any difference. But if they did, then ground 4 may very well greatly gain in strength. So it might seem, in terms of the legal argument, as if ground 4 is particularly important to you. But you also have to consider ground 4 against the context of your other grounds, which is the question of whether there ought to have been additional findings or findings about additional matters under 2 and 3, and whether the judge's findings of fact can somehow be attacked because of the activities of former solicitors under ground 5.
Yes.
And so I only intervene at this point because you've sort of said, well, the judge never thought about what would happen if the children went home without their mother. I say went to Nigeria without their mother. But you have a finding of fact against you on that, which is that they're not faced with that, whatever she may say, or whatever she may still say. So I think there are two parts to your review.
Yes, of course.
And at the moment, if you're going to be basing submissions about welfare on particular features, you're going to have to make sure that they're ones that accord with the judge's findings, because at the moment, as I understand it, you say the judge ought to have made more findings. And also you say that in some way the solicitor's negligence has some impact upon the findings about credibility. So up to you how you approach it, but you can't assume anything in relation to the welfare situation. At the moment, the welfare situation, from our point of view, has to be considered in accordance with the judge's factual findings, unless and until you succeed in disturbing them.
I hope that I don't assume anything, but I'm
No.
sure if I
Well, you did a moment ago when you said the judge never thought about what it would mean for the children to go back to Nigeria without their mother. At the moment, they're not going to be going back to Nigeria without their mother if the judge's order is upheld, because the judge found that the mother would not carry out her intention.
Well, I accept, of course, what the judge held in terms of the mother's intention. Of course, the order phrases that and structures that slightly differently, because the order envisages a return with the father unless something else happens.
Yeah.
Our main submission in that regard is that even with that, because of course, whatever the judge found, the mother may have indicated she would return or not. In fact, she didn't say she was going to return, and her position today remains that she won't. So one of our points is that the judge was required nonetheless to consider, in the context of a global holistic analysis of the children's welfare, what that would mean to them if, notwithstanding the judge's view that the mother would, in the end, she didn't. Because the consequences for the children would be significant, we say, if that were to happen. Now, it might be that a judge doing that would find that it remained in their interests because of the preponderance of other factors to return, notwithstanding that that involved a change of their main carer. But in this particular context and in these circumstances, our submission is that she was required to do that exercise, which actually, we say, even if this were a 1980 Hague Convention case, which it isn't, she would have had to do, albeit through the lens of Article 13b rather than welfare.
Yes, well, let's suppose you're right about that. I mean, isn't the first port of call to say to the judge, well, there's a bit missing here from the judgment, that you need to deal with the situation if I don't go back?
Lord, I would suggest that in this particular regard, that goes slightly beyond clarification of a judgment in a way that sometimes, albeit I accept that different situations call for responses in different ways, would be said to stray into re-arguing a case that the mother had not succeeded on. But the fundamental problem, as we identify it and submit, is that in this particular regard, and of course, I take all of my lord's other points about how these work together, and I will, I hope, in the course of charting through the grounds that we have, link them together. But what the judge was required to do here, as we've already touched upon, was an analysis of where the children's best interests lie, those best interests being paramount. That is understood now, and certainly in my submission in this context also requires to be understood as being an exercise in conducting a global holistic analysis. There isn't any reason to depart from that just because this is a summary return application, and indeed that is the message that we received from the Supreme Court in Re NY. That would involve identifying what the options are available for these children. On the face of it, depending on the extent to which return to Bahrain was pursued, but there isn't any indication anywhere that the father expressly abandoned that, the options for these children were to remain in this country while the court investigated their future in the way that Re J and the House of Lords suggests, to return to Nigeria with both of their parents, to return to Nigeria only with the father for a period of time while he was able to stay there, or to relocate to Bahrain. The judge doesn't identify those as being the available options, and she doesn't analyse them in that way. If she had have done, then her conclusion that the mother's decision not to return as communicated to her was tactical would form part of that overall analysis. It would be a factor in the global holistic analysis that she was required to undertake. But the judge didn't do that. In fact, what we say she did was a linear analysis, where she ruled out England and decided return to Nigeria, whatever that might look like for these children, notwithstanding that, as we submitted, and this is where the interaction between the difficulties in terms of determining habitual residence and the welfare analysis per Re J arises, that if one looks at these children's lives, their home country, as described in Re J, was, we submit, plainly here. I mean, this is why, or it could be seen as being an example of why the distinction that is drawn in Re J between habitual residence on the one hand, a technical concept, and home country on the other is drawn, because it is possible that if one looks at this case, one would decide, as this judge did, albeit we say she was wrong to do that, that these children had lost their English habitual residence through the move to Saudi Arabia and had then become habitually resident in Nigeria. But that is very different, we submit, to looking in the way that Baroness Hale does at paragraphs 33 and 34 of Re J, at where their home country is, which was undoubtedly in England, where they had been born, grown up, lived most of their lives, apart from a brief sojourn of 1 month in Saudi Arabia and 6 months or so in Nigeria. And as a consequence, we say, and I'm terribly sorry because I'm jumping ahead of myself here, but I hope not unhelpfully, that the focus on habitual residence and wrongful removal became a distraction, a focus on technical issues that the judge wasn't required to decide, but which she did in a particular way, which then caused her not to look at what Re J was telling her through the clear statement of principle in the House of Lords, which the judge adopted through reference to a decision of my lord in J&J, where a summary of the Re J principles were provided. It was a distraction from a focus upon that. It caused the judge to make a decision about something she didn't need to, rather than focusing on what she did, and then fail to build into her welfare inquiry the factors that she would have been focusing on if she had been looking at the right thing. So the focus on habitual residence, because of the, as we put it, the misdirection in the 4th of December order that carried through, had that real welfare impact, because it distracted her from what she was actually supposed to be dealing with, which would have been highly relevant when she came to the overall welfare balance in circumstances where, to come back, I hope, to the point that I was getting to before I distracted myself in this regard, if one looks at the agreed facts about these children in a case where there were very many things that were not agreed, they had two parents who were British citizens. They were born in England. They'd lived their whole lives in England. Their father had moved away in 2022 for work in Saudi Arabia. They stayed here with their mother, being cared for only by her in that period of time. They then moved to Saudi Arabia and were there for 1 month. Circumstances that were disputed, but in relation to which I accept the judge made particular findings. They then move again to Nigeria, but, and this is significant in relation to what we were just discussing, when they moved to Nigeria, it was for the specified purpose of D engaging in the therapeutic program that father had identified for him for a time-limited period on the basis that it was to prepare him for going back into school by the autumn of 2024 in Saudi Arabia. And of course, there they were also being cared for only by the mother, and they were there for 6 months. So that is the factual background here. Sole care by the mother for large parts of the children's lives, in England for the majority of their lives, in Nigeria only for a specified and temporary purpose that actually, by the time of even the first final hearing, which had to be adjourned because the father had not made his case ready by then, in terms of the passage of time at least, had passed. And yet, when we get to the final hearing, the judge is considering an application for summary return to Nigeria, notwithstanding that D's purpose there had come to an end. The therapeutic package that he was due to engage in had finished. He was by then supposed to be going into school, and in fact in England he was in school. So there were a number of factors here, aspects of these children's lives that were significant and important, that required consideration from a welfare perspective. But we say, because of the focus that the judge placed upon irrelevant factors, were lost in the sea of other things that she considered. There is then, as my lord rightly reminds me, within that, the aspect of the fact-finding exercise that the judge engaged in, where it was decided that it was necessary to determine the vast majority of the mother's allegations, but not what might, and I hesitate as always to grade different allegations in terms of seriousness, because for the person who is the alleged victim of them, they're all serious. But from an objective perspective, the ones that were not considered by the judge were extremely serious in terms of their nature and effect upon the person involved. But the judge didn't determine them when she could have done. She heard evidence from the parents over a long period of time. It would have been an additional burden upon her. But most significantly, she didn't consider from the perspective of the welfare decision that she was being asked to make, whether it was necessary for her to do so in order to inform that decision. And as we will come on to look at, when she expressed her conclusion in this regard, insofar as she independently reached one, although we say from the judgment it doesn't appear that she did, she made specific reference to those allegations not being relevant to the arrangements for the father to spend time with the children, which wasn't, of course, the welfare question that was before her. So she decided not to, albeit I accept, on the basis of both parents' agreement as it was expressed to her, decide those allegations, and the basis on which she said she wasn't going to, didn't in fact make reference to the welfare issue that she was deciding.
Just going back a little bit.
Yes.
The arrangements for these children were not run-of-the-mill, because this is an international family, at least when seen from the point of view of the father's employment.
Yes.
Which can't always be carried out in one place. Strikes me that if one leaves aside the question of labelling, habitual residence and home, that one might say that the significance which attaches to where a child's home country is bound to vary from case to case.
Yes.
And if one has a situation where you have a purely domestic family who've always lived in one place and then suddenly the children end up somewhere else, then in those circumstances, where home is likely to loom particularly large in a welfare assessment. In other cases, and this may be one of them, give you the opportunity to comment, it's much harder to identify where the children's home was because the judge made findings about what the parents' plan was,
Yes.
which did not involve living in this country any longer. And so there's a danger, isn't there, that we could substitute, we could say, right, the judge was wrong about habitual residence. I'm speaking for myself, you're pushing at an open door on that. But it would be wrong, wouldn't it, then to invest the idea of home as if it was a sort of convention concept that had to have some special meaning within the welfare assessment. As I've illustrated, I hope where home is will take the weight that it ought to take depending upon the children's experience.
Yes.
It doesn't mean you're not entitled to point to all the matters that you have listed for us, but we don't want to fall into the same trap of treating home as if it was somehow a starting point for every case.
No,
In Re J, Baroness Hale does say one might start from this position, but it rather depends upon what you're talking about.
I don't disagree. I think it's important to start by saying with anything that you've just said in this regard, where Baroness Hale talks of starting from a position, it is that there may be a weak presumption in favour of return in certain types of case. The reference that she makes within the judgment to home is, of course, in a particular context. It isn't expressed as a test, i.e. if England is the child's home, you don't return elsewhere. It is used by her, as I've said already, as by way of a deliberate distinction from habitual residence, but as a description or marker of connection. Yes. In the context of identifying within that, I should say speech, within her speech, particular factors that might be relevant to the decision to return or not.
Well, I'm very comfortable with that way of putting it, but it seems to me that to say that there's always going to be something that can be put in as a title or in italics as, quote, home, may be contrary to the flexibility that's needed with a welfare assessment. It'll really depend upon what the situation was, and it was only that point that I wanted to introduce to you.
I think and of course I say that this supports the main submission in relation to the focus on habitual residence, but what Baroness Hale really is identifying, starting from the point that this is a paramount welfare inquiry, is that it is multifactorial and there are different factors that will weigh one way or the other depending on the particular circumstances. And she identifies within the context of the case that was before them, but of course also of general application, different of those factors. And there is, because of the country that was involved in Re J, a particular focus on the legal system there and the concept of welfare that is adopted in that legal system. But the particular reference to home, of course, is in the context of a discussion about the impact on a child either way of staying in that particular place while the substantive decision
in this case, for example, I mean, the concept of home is not easy to square with effectively a flit from Nigeria without any notice to anybody, packing up and leaving and then disappearing in this country to a place that the children have never been before, where the father doesn't know where they are, and living in a refuge. So it's for that reason that I interrogate.
Of course.
So I don't. It seems to me we'd be making a mistake if we moved from saying, well, it wasn't habitual residence and it ought to have been a home, as if that was the dominant concept. It might be said that in this case the concept of home plays relatively little part.
Well, that might be right, but the reason I focused on that in the way that I have is because of the deliberate distinction that is drawn between it and the connecting factors that go to it, and the exercise that this judge in this case conducted, because it is part, and this is not, I hope, inconsistent with anything my lord has said, or indeed anything that I have said, of this multifactorial welfare inquiry that Re-J, and expressed in a different way through the 8 linked questions, Re-NY is saying should be conducted. And my point, moving one step further on from that, is when you have these cases that identify these factors, it is a strange thing, isn't it, then to read a judgment that is ostensibly providing for summary return under the inherent jurisdiction, where one gets to the analysis of it and finds no mention really of any of them. And that is where one gets to in this case. There is a lot of time in the judgment, or space, dedicated to the law on habitual residence. There is analysis of habitual residence, but where does one find the analysis of what the actual connecting factors of these children to this country are, expressed in relation to the question of whether it is in their best interest to remain here for a period of time while the main welfare question is determined, or whether it's in their best interest to go back to Nigeria for the welfare question to be determined there? And taking that submission one step further, where is the analysis on that part of the question, the litigation in Nigeria, in circumstances where the father has obtained a sole custody order there? Where is the analysis in the judgment of whether there's a relocation jurisdiction or not that the mother might avail herself of? If one considers how Re-J tells a court, or suggests the court at first instance should investigate these questions, where does one see that exercise being undertaken here? In our submission, you don't, because it wasn't done.
It's quite short, but paragraph 102 refers expressly to the father's case being that it was a temporary period in the first instance. Family had left England, the family home had been rented out, the children's school had been told they were leaving, and the school had wished them well. That's all, even if it's not under the right heading, that's clearly relevant to the question of times. I don't want to use a specific term, but it's relevant. It's as relevant to home as it is to habitual residence.
Well, my submission is that the heading is significant in terms of the understanding of this judgment, and what the judge is actually doing here is analysing a loss of habitual residence on leaving England, and that it is, as a consequence, a materially different exercise to considering their connections here now in the context of whether it is reasonable and in fact in their best interest to stay here while the substantive welfare decision is taken. What I would...
Rather than adopting labels, speaking entirely for myself, although I think it echoes something that my Lord Justice Peter Jackson said earlier. One view would be taking the findings of fact that the judge made and for the moment assuming you can't upset them. What's the consequence? Because on one view, the consequence is that Nigeria was a finding that it was in the best interests of the children to be in Nigeria is impregnable.
Well, I think our challenge in relation to that finding is that in circumstances where the overall conclusion that it was in their best interest to return to Nigeria is that in circumstances where it isn't in fact apparent that the judge considered all of the different things that go into a welfare determination, there's no consideration of the impact on the child of leaving this, on D particularly, of leaving the school that he is now in, of leaving the support structure that he has in place, albeit applications have been made for specialist support for him that haven't yet yielded fruit, but that is a structure that is around him, where there is no impact on, or no analysis of the impact on G of the arrangements that are made for her here, of the impact on the mother of being required to leave England, where she considers she is supported and safe, to a country, Nigeria, where she considers she is unsupported and unsafe, that there are very many reasons why the overall welfare analysis doesn't stand up to scrutiny. And we say that seems to have happened because this judge approached this case in a particular way, really as a case where habitual residents decided all and the outcome followed. So we don't accept the suggestion that the overall welfare conclusion is not open to challenge. In fact, the welfare analysis is thin, and there are a number of aspects of this case that we say the judge should have considered that she didn't.
Thank you.
Mr. Gresham, before you move away from this topic,
Yes.
could you just, you may be that you're going to come to this in a minute or two, but you've taken us to Baroness Hale in Re J and the way in which she distinguishes between the technical concepts in the convention and the welfare approach in non-convention cases. What do you say is then the message that lies behind paragraph 57 of Lord Wilson's judgment in NY, where he poses the question, in light of the policy in favour of the making substantive welfare determinations, did there need to be an inquiry into the child's habitual residence at the relevant time in the context of an application under the inherent jurisdiction? Admittedly, in this case, not a non-Hague case, but he's not really, I think, making the point that this is a Hague as against non-Hague. This is an application under the inherent jurisdiction.
Well, that is a question that we have found not particularly easy in the preparation of this case. And it seems to us, and we submit, that the answer to that likely lies in how Re-NY came to be before the Supreme Court. Because it was, of course, an application in the first instance for the summary return of the child to Israel under the 1980 Hague Convention.
Yes.
It was determined at first instance that the father had consented, and then the order was made for return under the inherent jurisdiction nonetheless. The Court of Appeal considered that it wasn't in fact a case of consent, there was no wrongful act at all, but upheld what it considered to be Mr. Justice MacDonald's welfare analysis, and the Supreme Court reached the decision that it did. The context of paragraph 57, of course, with the reference within it to the date of the hearing, seems to be a jurisdictional one, because it's contemplating within it, it seems to us, a situation where the court having, and this is the only way that one would reach this point in a 1980 Hague Convention case, the court having dismissed the 1980 Hague Convention case, it comes to consider the making of the summary return order under the inherent jurisdiction. And in that particular instance, unlike a case where a jurisdictional issue arose and an application had been issued, the point of deciding jurisdiction would be the date of the hearing rather than the date of any application. So it seemed likely to be a reference to determination of a jurisdictional issue. It can't have been suggesting that there needed to be an examination of habitual residence to inform the welfare inquiry, because that would be directly contrary to what Baroness Hale had said in Re J. And one might expect that if Lord Wilson intended to change or otherwise amend the approach that she suggested, it would specifically have been said that that is what the court was doing, and he doesn't. So it seemed likely to us that that arose because of consideration of jurisdiction, because that's the only reason that it seemed to us would give rise to the identified date.
Thank you.
If it were to be suggesting anything else, then that would seem to be a different approach to Re J, and we didn't think that that was very likely based on how it was expressed.
And so the final sentence of paragraph 57 really needs to be read in the context of the whole, including the was that sufficient to justify the making of a summary order 5 months later, i.e. we're looking not then at the date of the application, but the date of the...
Yes. I mean, this is effectively, we're into arguments about ground one in this regard in any event, but one of the points that we wish to raise in relation to this is, of course, when the judge considered she was deciding habitual residence in this case also, because she was looking at the date of the application, which is another important distinction and another important reason as to why her conclusions about habitual residence are not capable of being imported into the welfare inquiry, because of course if one's looking at the paramount welfare of a child, one does that at the time that the court is considering it. The position isn't fixed in aspic at the date of the application, but that is what the judge was dealing with here.
You will know from your involvement in the case, but NY was a particularly unusual case, wasn't it, in which a summary return order was made in a Hague, in relation to a Hague country.
Yes. There was, of course,
at least at one point was made, yes.
I'm sorry.
It was made at one point in respect to the Hague country. By this court, was it?
Well, there was Re KL in the Supreme Court, which was an American case where the father's Hague Convention application was dismissed for technical reasons, for lack of habitual residence at the relevant time, but the Supreme Court made a summary return order in the exercise of the inherent jurisdiction. But
your understanding really of paragraph 57 is that it springs from the fact that NY was an unusual case in that there was intersection between the convention and the inherent jurisdiction, which doesn't exist in the present case.
yes.
Or in most cases.
Indeed.
In most cases, it ought to be possible to see whether one's really working under the convention or not.
Yes. But also, if we are right, and I've made my submissions about this, that this is related to jurisdiction, of course the court needs to know what jurisdiction it's exercising and what it's dealing with. And of course it will be important in a situation like that which faced the court in Re NY, where there has been what the Court of Appeal considered to be an entirely lawful move from Israel to England with the consent of the father, who was then seeking summary return. Of course, the court will need to know if, notwithstanding that particular scenario, return is sought under the inherent jurisdiction, whether the English court has a substantive welfare jurisdiction or not, on the basis of habitual residence or any other basis, including presence. So if that is the focus of it, it's an entirely understandable comment to make, and it is, of course, something, I mean, it's not really fair to describe this as a comment, I suppose, but it's entirely understandable that Lord Wilson will have raised this as something that the court needs to consider, because there would be a material difference in approach between a situation arising in that context within the course of 1980 Hague Convention proceedings, between one where habitual residence had changed in the time since the alleged wrongful act and one where it hadn't. But it is as I hope I've recognised, an entirely fair question, and it's not one that we found entirely easy, but we couldn't find an alternative explanation based on the way that Lord Wilson expresses himself and the focus on the date, which can only really, we suggest, relate to jurisdiction. Can I just turn my back for you? I'm reminded that at paragraph 35 of Re NY, Lord Wilson describes Re J as being impeccable, so he can't really be suggesting by paragraph 57 that some difference in approach was required. As I said, I think we've gone into the territory, in fact, of more than ground one, but it's convenient probably to go into that now in a little more detail. I mean, in fact, I've rehearsed many of the submissions that I intended to make about many of the grounds already, so I won't, I hope, labour points, and I hope also not to repeat myself in relation to them. So can I invite you, if I may, just to turn to the judgment?
Are we moving to the grounds now, or?
Yes.
Yes, and starting at one?
And starting with one.
Thank you. I mean, can I help you to these? Because obviously we've exchanged views about this particular point. That by all means take us to all the many references to habitual residence that we find in the judgment, or the way that it's set up. But I think you, as I say, are pushing it an open door in relation to the fact that this really had no place in the particular questions that the court had to answer. And what we're particularly interested in is your analysis of what difference it can be seen to have made either by commission or omission in the judge's subsequent analysis. So with that, I hope to help you.
Of course. I just wanted to point up the reference in the judgment to the point that I was just making about the date that the judge was looking at, just by way of reference, really. But it's at 107.
Paragraph or page?
Page 107.
Thank you.
Beginning in this regard at paragraph 70. Taking this relatively quickly, mindful, my lord, of what you just said, neither of the cases at paragraph 70 seem to be on any relevant point. They deal with the dates of determination of habitual residence when deciding jurisdiction under the Family Law Act 1986 and or the 1996 Hague Convention. But she applies them at 71, and I accept, of course, that it said there is no dispute in relation to this, but the fact of the matter is, in our submission, whether it was in dispute or not, it was wrong. That she ought to be looking at the question of habitual residence as of the date of the father's application. In terms of where that then takes the judge in her analysis, accepting that she needn't and shouldn't have been looking at this at all, but mindful of the argument that, in fact, one can export her conclusions about habitual residence and apply them to the welfare inquiry. She deals with these, and we were at this paragraph a moment ago, at page 123 in the core bundle, paragraph 102. It's quite clear in our submission from those paragraphs that the judge is looking at factors 102, and I've made this point, that would be relevant to a loss of habitual residence in England upon the family moving to Saudi Arabia. And that 103, acquisition of habitual residence in Nigeria during the period spent there. And then 104, her conclusion in this regard, mindful of the date that she's identified she's looking at here, the children were settled and integrated into life in Nigeria, clear that they had their habitual residence there. And then at 105, what she says is the impact of that, notwithstanding this finding, it's open to me to consider the best interests. Well, it is, in our submission, completely plain that she was considering the situation, as indeed she said she was, at a particular moment in time. That she considered that was all that she needed to do in terms of looking at the children's connections in different places, that it was looking at the date 28 June.
Right, so one consequence you draw from the misdirection, you say, is that it led to the judge looking at the situation in June and not in January.
Yes. And had she been looking, however one describes it, whether one does this with reference to paragraphs 33 and 34 of Re J, or just through an application of the welfare checklist, very many things had happened in the children's lives between June and January, I mean, not least of which the starting of school for D. Some of those things might have been said on a proper welfare analysis to show increased connections with this country beyond the fact of their lives here before. Certainly, for a child that has the particular needs that D has, the impact upon him of being placed into a school environment and then, on a summary basis, which would be the effect of the judge's order, removed from it, would be a significant factor that any court, in the context of a full welfare inquiry, would be required to consider. The judge directs herself at paragraph 106 to the welfare checklist. She says at 107 that the findings that she has made throughout the judgment form part of that analysis. At 110, she considers the local authority assessment from September 2024. But then she goes on to consider the father's evidence about his position, evidence of the relationship between the father and the children, the mother's current circumstances, specific regard to the children's ages and wishes and feelings, although it is a factor of this case that there was no CAFCAS report, and there doesn't seem to have been, on the information we have from the case management orders, any consideration of whether or not there should have been one. So there's no direct information about the children's wishes and feelings, which leaves the judge at 114 to make assumptions about what they would want.
113 is clearly a contemporaneous assessment, not a historic one, isn't it?
In relation to the mother's position?
Yes.
Yes. But then when one gets to 116, where the judge expresses her view, standing back and looking at the facts that it's in the best interest of the children to be returned, and the subsequent paragraphs, there's no analysis of the children's up-to-date situation and the impact upon them of being removed from that. And we submit that is likely to be because, I mean, that is a failing in and of itself. It isn't a proper application of the welfare checklist because there's no analysis of the impact on the children of change. But that's likely to be because the judge artificially cut herself off from considering connecting factors, whether one describes that as home or in the more general way that paragraphs 33 and 34 of Re-J do. No impact on the children of being removed from that, but that's the impact of her decision. And the consequence of that decision is a return to a country that the children have in fact only spent a few months in for a particular specified purpose, without, on the mother's case, I accept, of course, not accepted by the judge, but that's her position, her being there with them. So there is the misdirection, but the consequence of the misdirection is an excision, really, from this case, or at least from the judge's analysis of this case, of, by then, 7 months of the children's lives. Longer, in fact, than they spent in Nigeria at all, and a failure, perhaps because of that, of course one doesn't know, but it's not expressed in the judgment, to consider the impact upon them of being removed from that environment after they had been here, albeit with the mother doing the best she could with support of charities and refuges, for that period during which both had entered school. So there is, in our submission, a significant and real-world impact upon the welfare analysis that the judge conducted of the misdirection. And that, really, to come back to where I started in relation to this ground, is precisely what Re-J in the House of Lords was trying to avoid. This is why we do not import into inherent jurisdiction welfare inquiries, whether conducted summarily or partly summarily or otherwise, Hague Convention principles, because they are directed towards a different thing. And this case shows, regrettably, the consequence of blending those two together. This perhaps is at risk of, if you accept this is a lily gilding it, but the reference to wrongful removal adds to the problem in that regard. Because, of course, the presumption under the Hague Convention...
I'm not sure that it had quite the same impact, does it? Because however one describes it, what took place in this case was pretty stark.
Yes.
But I entirely agree with you that concepts of wrongful removal are part of the same era.
All that I was going to say about it was that, of course, if there has been a wrongful removal, we operate under the convention on a presumption of return. And it is at the least an unfortunate use of language in a case where there is no such presumption, really. But it might suggest a particular focus or approach on the part of the judge that falls into that area.
It's not one of those cases where one can perfectly well see that it's a slip of the tongue. Because on the 3rd of December, it was set out as being the second issue that the judge was going to have to decide. So it was a perfectly deliberate introduction of the concept into the case, which is a feature of what we have to consider.
Indeed. Unless then anything arises in relation to ground 1, I was going to move on to our grounds 2 and 3.
I wonder whether, is it most convenient to, do you have more to say on ground 4, or in a sense, have you packaged the error and the consequence? Because as I said before, I think it seems to us that those two, although separated in the grounds, are rather two ways of saying the same.
The other point that arises in relation to ground 4 is the treatment of the mother's position and her statement that she's not going to return. I mean, I appreciate, of course, entirely what is said against me in that regard, that the judge concluded that was likely tactical and that she probably would go back. But that is not the mother's position. And she remains firm in her instructions that because of her experience in Nigeria, she isn't going to go back. And as a consequence, we do submit that, and I appreciate I am falling into the error that I say that the judge fell into here by bringing into this Hague Convention considerations. But in a Hague Convention case, in our submission, where a parent says, I'm not going to go, my lord has made a decision about this relatively recently, well, last year, where a parent says they are not going to go, the court can, albeit not expressed perhaps as a finding because of the particular restrictions that exist in such cases, reach a decision about whether they're likely to follow through with this or not. But the court, nonetheless, in our submission, has to go on to consider the defence that arises in relation to that, Article 13b, if the parent follows through with what they say they will do. Because, of course, the difficulty with parents stating intentions and judges reaching conclusions about them is that, notwithstanding what the judge says the parent is likely to do, they may do the opposite. And if they do the opposite to what the judge says, that will have a consequence. And the consequence here, if the mother remains firm in her instructions that she won't return to Nigeria, will be that these children go back without her. And that is what the judge ordered, in fact. And, albeit there are difficulties that we've looked at in the structure of that order, in fact, the first option for return is return with the father. But the judge does not analyse the impact upon the children of that at all. She orders it in the alternative. Now, one might think, if in fact she was firm in her belief that the mother would go back, it wasn't necessary for her to do that. But if you're going to make an order in our submission that says these children who have always lived with their mother will return with the father, it is incumbent on the judge who does that to engage in a welfare analysis about it and to reach a conclusion.
I follow that point very clearly. I'm not sure that it's fair to say that the return with father was the first option, but I appreciate that it appears above the other one in the order. But actually, the first moment was the mother's election.
Chronologically, the mother has the right of refusal.
Yeah. Well, she had the right. She had the right to change her position.
Indeed.
In which case she had priority.
Yes.
So,
my lord's entirely right to express it in that way, and I apologise for being.
No, not at all. But your key point is that additional to all the matters that you've already raised, that you say the judge should have paid attention to in welfare terms, which have been exposed through your ground one argument, you say there's also the non-return of mother issue to be added to those when considering ground four.
Yes.
But just to keep our thinking in order, and please take whichever direction you want to take. It's convenient to know whether we're going to return to ground four at some point, or whether, in a sense, we've done that.
Forgive me. My lord tried to get me to answer that earlier, and I didn't. That having been said, with that, we say, important aspect added onto it, that is grounds one and ground four.
Right, and those are two sides of the coin, the error and the consequences.
Yes.
Well, there may be other things that occur to you as you complete, but I've certainly understood what the way you put it.
My lords, then moving to grounds 2 and 3 in relation to the failing, as we express it, properly to deal with the fact-finding exercise. Well, as we set this out in some detail in the skeleton argument, which is at page, in this regard, 26 in the core bundle, beginning at paragraph 28.
It's really the same point under these two grounds, isn't it?
Yes.
I mean, one is considering reference to 12J, and the other is considering it including 12J. Is that how
Yes.
it's done?
And we've dealt with them in that way, and the skeleton is
Okay, so it's
effectively
one
rolled up.
point that's being made here.
It is. It's a rolled up argument in relation to both. The principles that we draw from 12J as set out in the skeleton argument are not challenged and not capable of challenge. They set out what a judge is required to do when deciding whether or not to hold a fact-finding inquiry, and then in shaping that inquiry. The key point that we make in relation to this is that the obligation at all stages, and this arises from PD 12J and also from RE-HN, which, because this principle is not challenged, we haven't troubled you with in the authorities bundle, is that the obligation here is on the court, not the parent. Parents' views as to what allegations, well, firstly, as to whether there should be a fact finding, and secondly, as to, if there is to be, what allegations required to be determined are relevant, and the court must take them into account. That's what PD 12J requires. But the overall obligation is on the court to consider that, and particularly to consider, when deciding what allegations to deal with, their relevance to the welfare exercise. The difficulty that arose in this case, simply put, is that upon being presented with a parental agreement that the sexual abuse, sexual assault allegations of the mother need not be determined, the judge seems simply, without further analysis of it, to have agreed with that position. As we point out, the judge at paragraph 33 of her judgment when dealing with this, and that is page 92 of the core bundle, sets out the suggestion that these allegations need not be pursued by reference to a welfare-based assessment, but it appears that the position advanced on behalf of the mother then was that they need not be pursued or dealt with because they would not, quoting directly from the judgment, of themselves impact on the approach she would then invite a court to take in relation to any welfare-based assessment of the father's time with the children. And whatever this case was about, in whatever form the court was deciding it, whether it was, as I've described it, a classic summary return or involved Bahrain or whatever it might be, this case was not about the children spending time with their father. It was a wider decision than that. So if that is the judge's analysis, she directed that analysis towards the wrong issue. But our main submission is that she didn't in fact analyse this position at all, and that had she have done so, it would have been very clear to her that those allegations were of relevance in various different ways to the welfare exercise that she was engaged in.
Because, yeah, very basic question, but why?
The mother's allegations ranged across a number of different headings.
I think it might help when we're considering this if we just had in front of us the supplementary bundle at 439, because that is where the mother's case in its fullest sense was set out in respect of allegations against the father.
Thank you. Indeed.
As I've understood it, she pursued all of the 7 heads, bar the parts of the first one that referred to sexual matters.
Yes.
So she she persisted in allegations about psychological, emotional and financial abuse. She said that she'd reported those and matters relating to sexual abuse and rape to the police. And she also told the court that the father had encouraged the family to abuse her and the children.
Yes.
So, in a sense, when one looks at the whole document, she pursued the whole lot, apart from the matters that you're now focusing on.
Yes. And I'm not suggesting that you need to turn it up, but just for reference, the mother's allegations are detailed within her statement at C.
In more than one statement, I think.
In more than one statement.
She describes the behaviour
Yes.
of which she complains in those regards.
Yes.
Yes.
The first reporting of that is at C50, and it charts through a number of paragraphs from there, some of which are specific to this particular issue. But in order to answer the question as to why they were relevant, they are relevant in a large number of possible ways. But from a starting point, if a man will behave that way towards his wife, it undoubtedly says something about him and how he perceives her and how he is willing to treat her. So it may impact, depending on the judge's view, and she makes, I'm afraid the precise reference escapes me, but she makes reference in her judgment to the father holding a somewhat traditional view of the married relationship, of which this may, if the judge had examined it, form a part. But it is a particularly serious aspect of abusive behaviour because of the power dynamic that is involved in it. And if the judge were to find, and we, of course, we don't know whether she would have or not because she didn't consider it, but if the judge were to find that he had behaved in this way towards the mother, it might have impacted upon her view of how he behaved in various other ways. It also, as an allegation and an aspect of behaviour, has a particular and specific impact on the victim of it, and is likely to inform how they view that person's interaction with their life and in their life going forward. If the judge had considered and found that the mother had been treated in this way, her view about the mother's approach to returning to Nigeria may have been different. If this is behaviour that somebody had experienced from a person, being required to go to the place where that person wants you to be and saying, no, I'm not going to do that, the risk is too great, may seem entirely reasonable rather than unreasonable. It also impacts upon, in our submission, how a court would view the safety of that person's contact with children. And indeed, albeit I appreciate this is not a straightforward issue at this point, but there was Kafka's guidance that where allegations of rape have been made, the starting point from a Kafka's analysis basis would be no contact. So from an overview, as it were, without getting into the specifics of the mother's evidence about it and how she experienced this behaviour, there are various ways in which this was likely to be a relevant issue.
As new counsel, do you have any idea, and have you made any inquiries as to why it appears to have been a joint view that these allegations were not relevant?
Well, we have made inquiries. I'm obviously careful in relation to issues of privilege, but my instructing solicitor has examined the file. There is very little, and this might seem not to be unexpected, bearing in mind the other criticisms that were made of the mother's solicitors, but there's very little by way of note-taking of the instructions that the mother gave. She received certain advice about how the court might perceive this allegation, bearing in mind the married relationship of the parties, which seems...
The reason why I ask, sorry to cut across you,
Not at all.
is that in other jurisdictions, where you have what is at least by implication, a very serious criticism of previous legal team. Underpinning your client's actions in taking the joint view that it was not necessary to to resolve these issues. The court would expect that those who were advising would treat it effectively as a waiver of privilege and would expect the new legal team, before they make these very serious criticisms, to make specific inquiry so that the court can see if there was any apparent basis.
Yes. My lord, we have made inquiries. There is not a great deal of information about this. On a straightforward basis, if one takes at face value the concession that was made to the judge, that it wasn't relevant to spending time arrangements, it was wrong. Firstly, because the court wasn't dealing with that. Secondly,
I know that's your submission, and I know that's why, I think I understand the reason why you say it's wrong. But what troubles me is where you have and apparently, and obviously the question also arises for the other side, who may be able to provide better information. But what troubles me is having a major plank of your submissions unevidenced in critical respects.
well, I don't. It may be that I'm misunderstanding your question. The major plank of our submissions is that whatever the parents were saying to them, whether it's right or not, the obligation is on the judge to undertake an inquiry themselves into the relevance of these issues. It is not open to a parent under PD 12J simply to say, well, I've advanced this in evidence and it's in my, such as it can be described as one, schedule of allegations, but I'm not pursuing it, and that to be the end of the matter. The judge takes into account their view, the judge can hear what they say about not pursuing it and why, but the judge has to take an independent decision based on an analysis of the case and the factors under PD 12J and decide whether they are to be determined or not.
But it goes to the father's point that the guidance or the mandating goes to disputed facts, and we've got a case where your client, to put it bluntly, has been roundly disbelieved on a number of her allegations. And so one possibility, and I'm not going to go down this speculation, but it's the reason why I have a concern, is that your client was backing off. I know she now says, no, I wasn't, but she was backing off the dispute. So there wasn't a dispute. And that's where my concern comes from.
Of course, we understand that. She wasn't withdrawing these allegations. I mean, that is part of the difficulty here. I understand, of course, on a technical basis, that if the court does not consider and find them from the perspective of risk assessment going forward, those allegations don't happen. It is a binary value of naught. But the mother wasn't withdrawing. The judge expresses through her judgment that it was said to her they weren't pursued because they weren't relevant. Insofar as this is a criticism of the analysis of the previous legal team, then yes, I don't accept that they weren't relevant. And I've expressed to you in answer to your question all the reasons why they probably were. The difficulty, though, then arises in how the judge treated that position as expressed to her, because it wasn't on the basis of PD 12J, the judge's role was not simply to accept that, advanced on an incorrect basis as it was, because the welfare issue identified in that apparent concession was the wrong one, and to move on from it. What the judge was required to do was to analyse that, taking into account that the mother said it. And of course, a judge, I entirely accept that it would be a difficult position for a judge to be in, to be faced with a mother in this situation saying, well, I don't want you to determine these allegations, and then to say to that person, well, I think they're relevant, and so you must pursue them, without situations as emotive and as personal as those that are the subject of these allegations. And that would have been...
What is a judge to do?
Well,
if you have a position where the the mother says, I'm not withdrawing them, but I do not wish to pursue them. Surely the logical consequence, if the judge goes down the route, is to say, these are not proven.
It might be. I mean, the judge didn't
Well,
do
not
that.
might be, must be. If the mother says she doesn't want to. I may be off the wall on this, but I'm coming from a different jurisdiction.
I think
But I confess that I'm troubled by it.
with my answer to your question, I think I jumped ahead a step. The first thing that the judge has to do is to consider them with reference to the welfare issue and decide whether they are relevant or not. The judge can say, well, notwithstanding that you have said to me, just to root it in this particular case and the way the concession was advanced, the judge could say, notwithstanding that you have said to me they're not relevant to spending time arrangements with the father, that isn't what this case is about. And I do consider that they are relevant, and I do think they should form part of the consideration of the factual background here. The person making the allegation would then have to take a decision as to whether they were withdrawing them, really, or not. If they withdrew them, the consequence would be, as my lord says, that they would be treated not to have happened. But what we ended up with here in our submission is this unhappy middle ground where they're not pursued, they're not dismissed, they're not withdrawn, they're just there.
I certainly agree it's unhappy.
Yes. And the basis on which the judge has accepted that is wrong, and she hasn't done the analysis to
we
get
don't
there.
have, I mean, one thing that we could have, which would not have caused anybody any difficulty if it could easily have been obtained, was a transcript of the exchange in which this was made clear to the court. So there's clearly something that was available that hasn't been
Yes.
sourced. I think it might be helpful just to make sure that we know what we're talking about, to look at, you didn't want to take us here, and I quite understand, and we don't need to read out what it says, but the references, I think that the primary references to this issue in your client's evidence were at supplementary bundle, firstly 52 at paragraph 11. You may be able to add things or to correct things, but I seem to find at paragraph 52, paragraph 11, the first key allegation of that kind.
Yes.
The starting point.
That is.
And then that was then, we needn't, I think, go to it, but that was then denied. And then I think we go to possibly page 55.
Yes.
Paragraph 25, but over the page. Sorry, I beg your pardon, there's a different paper bundle numbering. It's C53, page 55. We're talking about paragraph 25 going on to the second page.
Yes.
With some description.
Arguably also 23.
Yes, I see that as well. But we don't have to do an exhaustive search and so forth. But those essentially are the points in your client's evidence in which she brought up these matters for the court's consideration. Yes.
Indeed.
If the judge had, under paragraph 17 of the practice direction, one of the matters that the court considers is obviously the views of the parties, and we've been discussing what the views of the parties were.
Yes.
But also whether there is other evidence available to the court that provides a sufficient factual basis on which to proceed. If the judge had said here, I won't consider rape and sexual assault, but I consider that there is sufficient of the other 6.5 points that the mother has raised in her schedule on which to proceed, would that have made her decision then objectionable?
Lord, I would suggest that it would, because it is an example, isn't it, of the phrase sometimes used is siloing evidence. It's like we hive off this bit as being unconnected to the others. But the mother's, if one were to roll up all of the mother's allegations, they relate to a pattern of conduct played out in different ways over a long period of time. And so in our submission, it's not really possible to take out this one aspect of, if it were proved, very abusive conduct played out in, go back to the submissions I made in response to my lord about what they say about a power dynamic within a relationship and how one person sees the other. Because if the judge made those findings, it might have impacted upon how she viewed other aspects of the father's behaviour or other aspects of the mother's evidence about that. So in my submission, it's not really, it wouldn't have been possible if the judge addressed it in that way to deal with it like that, because it still leaves an important aspect of the mother's case about conduct, a pattern of behaviour, unresolved, that might, if one considers all of it, impact upon her findings about other things. So, my lords, we do say that on that basis, this was a fundamental error of approach that again would have had or did have a wider impact in how the judge dealt with the factual background. I think background is the wrong word. The disputed facts in this case. And the consequence of her not having addressed this part is really, as I've just said in my answer to my lord's question, that if this is not determined, not withdrawn, one can't know what impact it has on other of the allegations that the mother made, which of course the judge did not accept. But she didn't accept them, excising from her consideration a fundamental aspect of the mother's case about how this person treated her.
Sorry to step back, but could we also just look at the father's response at 139? Page C137 of the supplementary bundle. Paragraph 18. That was how matters stood before that issue was taken off the table.
I'm sorry, my lord.
Sorry, just paragraph 18 is really where,
yes,
it spreads into other parts of the statement, but this is the father's third witness statement. Gives his broad response to
yes,
to that. And you say it doesn't matter that this might have been nested amidst what the judge found to be a whole raft of false allegations. When one looks at it, she nevertheless was obliged to investigate that, whatever position was as first presented, or at least to scrutinise why it was that it was no longer being pursued.
yes. And the difficulty, of course, is that her decision not to investigate it comes before she's decided that the other allegations aren't proved. So
no, but for the purpose of the appeal,
yes,
when I
Oh,
having
well,
to look with a perspective on the situation, that knowing that it was nested amidst, subject to your last ground,
yes,
matters that the judge found to be false.
yes, Lord, indeed. One can't take her overall conclusion about the others and roll it up and say, well, because the mother wasn't found to be truthful about these things, she must be found to be untruthful
No, but
about
it's
this
to do with the question of what the consequence. And let's suppose you're right, and that the judge was obliged to look in more detail at these matters, notwithstanding what a represented party said about them, and notwithstanding the fact that we could at least have had a transcript in which we could have seen what was actually said at the hearing about them. She was obliged to do that. We nevertheless need to consider whether that was something that was procedurally unfair and leading to injustice.
Yes.
And so it's the consequence of it that we need to consider now that we're hearing an appeal.
Indeed. Well, of course I accept that.
And with that, in that situation, we have to situate this issue with all the other issues that we're having to
Yes.
contemplate.
But or to address that as shortly as possible, if the judge had heard this and had decided that about this particular aspect of the parents' relationship, the mother was being truthful, that may well have impacted upon the other findings, because of course one doesn't consider each finding as a standalone thing. The evidence one receives and the conclusions one reaches about each finding impacts upon the other. And it's a different way of expressing the not considering evidence in silos point.
Yes. Thank you.
Lords, unless there was anything further in relation to that, I was going to move, and only briefly, because I suspect I've trespassed beyond any reasonable amount of time I would be afforded, to ground 5.
Yes.
Lords, this is addressed within our skeleton argument at page 32 of the core bundle, beginning at paragraph 48. Well, Lords, the simple and straightforward point that we make in relation to this was that this case, in amongst all of the other difficulties that it encountered on its journey through to its final hearing, was bedevilled by what transpired at the hearing in December, as a consequence of which the judge found the mother's solicitors, who remained in circumstances that continued to be slightly opaque, but remained acting for her through to the active final hearing, had been negligent in a very important respect, in that they left the mother without any representation on that particular day. The consequence of which was, as you will have seen from the cost judgment, the making of a wasted costs order against them because of the costs thrown away paid by the father, the mother being publicly funded. The judge does, within the judgment, make reference to her conclusion about the mother's solicitor's negligent preparation and conduct of her case, but nonetheless goes on to find and to advance as a reason as to why the mother wasn't believed on her findings, the evolving and changing nature of her evidence as it progressed. And our short point, and I really don't want to labour this beyond the submissions made in the skeleton argument, is simply that in circumstances where there had been a finding of negligence, a significant and serious thing with the consequence of the wasted costs order being made, the judge should have considered in more detail what impact that was likely to have had on the preparation of the mother's case in writing and the evidence that she was giving orally, and given in effect to the mother greater credit, or leeway is the wrong word, I'll stick with credit, greater credit in relation to any discrepancy.
I understand, Mr. Commissioner, how you get any credit out of the fact that your solicitor's been negligent in relation to the booking of counsel for a hearing. That I can quite understand if the judge had found that the preparation of the mother's case had been shambolic, But we've just been looking at the fact that we have here your client's first witness statement at paragraph 50, your client's second witness statement at paragraph 72, which runs with exhibits through to page 121, 50-page statement, and further documents, page 436, reasons why I can't go to Nigeria. You're going to have to, at least as far as I'm concerned, go a lot further than showing that they fouled up the booking of counsel, because what the judge was saying was, faced with those circumstantial accounts of her evidence, which go into considerable detail, are you saying that the judge was then somehow obliged to apply a discount to the fact that the evidence that was given orally was unsatisfactory?
Not, my lord, a discount. Forgive me, I'm just trying to...
You said credit, I'm saying discount. It's the same point. Because I'm not understanding at the moment what the negligence that undoubtedly occurred in this case has got to do with one's ability to give a fair account of oneself, and in this case in considerable detail.
Well, I hope you will forgive me referring in this regard to a document that you don't have, but it can be provided if it's material. But it was submitted on the mother's behalf in written closing submissions that the judge received, with particular reference to the alleged inconsistencies in the mother's evidence as between her written and oral submissions.
Right, so we've got the opening submissions by both parties, is that it?
No, so this is written closing submissions that were filed on behalf of the mother. They aren't, in fact.
Are they not in section F?
It's not 485.
It is at 485. I had understood, I'm terribly sorry, I had understood you had a condensed supplementary bundle including only the statements, but it is indeed.
We were sent section F separately.
Well, well, there we are. Then you are at greater advantage than I thought, and I didn't need to apologise.
So which is the closing submissions that we're meant to be looking at?
So it's at 485. Closing points over, so
Could you give me the letter number? Is it?
F45.
Thank you. That's what I thought.
At the, so there is the heading, I hope, in bold, inconsistencies, and the submissions that were made in that regard.
Is that a response document?
I don't know what the order of the closing submissions
Well,
were.
because it doesn't, one doesn't normally file a document referring to the inconsistencies in my case, unless somebody's said there were some. But
I think my lord is probably right, but
The basic problem is, even which at the moment I don't see what you get or how you get away from it, is that the judge's finding was that the evolution started from an apparently fixed point of a witness statement which she had said was true and she had endorsed. And
yes,
I confess that I have not looked at F45 before just now, and you can't. At the moment, I don't see how you can. Similarly to my lord, I don't see how you can pursue ground 5 without a degree of specificity about to undermine the suggestion that she had endorsed the original statement,
my lord.
which you can't do.
There we are. I've drawn attention to this because it shows the submission that was made on her behalf in this regard, which we say through ground 5 should have alerted the judge, bearing in mind her previous finding to difficulty, I accept my lord's point about the lack of a distinction, perhaps, between credit and the term my lord used, but there we are.
Are we left now? I know my lord put it away, but he'll have seen it. But that at page 485, there's one bullet point which says that the court is invited to find the preparation of the case has not done justice to the respondent's case, and she must not be perceived to be untruthful due to failures on the part of her solicitors. That's what you're anchoring this to, is it?
Yes.
And what I'm trying to see is where, and it may not be in this particular document, but the previous paragraph refers to solicitors and a paralegal, but that isn't by way of criticism, it's just by saying I get asked questions, I remember things, I get asked more questions, I remember more things. I'm not seeing where failures on the part of the solicitors are identified in this, but I've only just read it for the first time now.
My lord, that is the document.
Right. So it's essentially the same point as Ground 5 makes, namely there were failures on the part of the solicitors. The only one that we've so far alighted upon is they didn't book counsel, and that therefore the judge should have taken a different view of the credibility assessment.
Yes.
All right. Well, we've got that point.
Well, can I turn my back?
So,
Unless there's any...
no, thank you very much indeed, Mr. Gratian. Yes, Mr. Tyler.
Well, may I begin by making a few general and preliminary points, please? First of all, and sorry to repeat a quotation, no doubt you hear in every appeal, but it's Lord Justice Lewison's line in Phage.
Don't worry, we can. We're well aware of the advantages of the trial judge, and you've given us conveniently all the authorities on that point.
Well, I wanted just to develop the trial as the opening and the closing night, not a dress rehearsal point.
Yes, well, you might say that simply because there's a change of leading actor, it doesn't mean that you're entitled to get a fresh start.
Indeed, and my lords have observed that the mother was represented throughout, participated throughout. Crucially, we say, when it comes to looking at the minutiae of criticism in the appeal, there was no request to clarify or to add to any part of the judgment. And of course, when a new team comes on board, it's easy to criticise parts of the process, but it's important to make sure that one sees exactly how the process unfolded. Because
you might also add, I suppose, I'm intuiting that there was no application for permission to appeal to the judge, but I may be wrong about that.
I'm not aware of one.
No,
and
because that's quite often, if you tell the judge what you're going to say about it, well, she might very easily say, well,
indeed,
since you ask. Yes, all right. So no application for permission to the judge.
And of course, when criticism is made, for example, I'll move on to this in more detail in due course, but to the judge's treatment of the "we don't wish to proceed with the sexual abuse allegations," thank you point. If that is an agreed position, then one would expect relatively short form treatment of that in a judgment.
Well, you also might, in this case, say that actually ground one, which is that we shouldn't have wasted time on habitual residence, wrongful removal and things like that. I mean, had the judge been addressed with ground one as it's being addressed to us, she might then have had an opportunity to consider why it was that she was doing it, since she'd been invited to do so apparently by both parties.
Indeed. And I'll take my lords in a moment to some of the detail which we can glean as to how the trial proceeded and to what in fact was put before the judge, which explains, we say, perhaps some of what is now the ex post facto criticism. And still on the opening and closing night point, but dealing with the observation made by my Lord Justice Stuart-Smith about what happens in other jurisdictions if criticism is effectively made of counsel. My experience in this court, in a family case, is exactly as my lord indicates, that if a litigant appellant significantly relies on failings of a previous team, then they can be expected to waive privilege on that point, and for the team so criticised to be able to make comment. And particularly in reference to the sexual abuse withdrawal, effectively, or non-proceeding with, I'll develop this in due course, but without having pierced that veil of privilege, it's unfair to the respondent simply to be faced with an undeveloped, unreasoned, vague suggestion it must have been somebody else's fault. And of course, we all know, it may be that those of us at the bar have dealt with this more recently than my lords, but there are all sorts of reasons why one takes a particular stance, or client takes a particular stance based on advice, which aren't then developed before the court. I'll say more about that particular point, but there may be all sorts of reasons why, in fact, there was good tactical reason for the mother to have taken the decision she did. Second point, and again, it's the Piglovska point, but of course, your lordship to know exactly what advantage this judge had in seeing this whole process play out, in seeing the actors before him in court, in having seen them, in fact, for several previous hearings. And the relevance, in particular, in this case, is that the findings of fact she made are far-reaching. They're almost all clearly based on positive evidence in one direction or the other. Nowhere does the judge say, well, stuck with two differing accounts, I simply have to rely on the burden of proof. I can't find X fact proved. More often than not, there is a good countervailing evidential basis for finding not just not proved, but finding otherwise. And that comes to the relevance of the binary issue. And of course, if a fact is simply not proved, it's a zero. But there's scope, as happened here, for the converse finding to be found, to be made, not simply identifying the mother's allegation of X to be made out on the evidence, but I have positive evidence on which I can find the contrary to be true. Which is why, of course, the judge was able to make the other comments and findings she did about the mother, and assuming Mr. Gratian isn't successful in unpicking the findings on his ground 5, the findings then that are made of effectively, actively, deliberately, tactically inventing knowingly false allegations in order to further her case are pretty significant findings and quite rightly factored into the subsequent analysis. The other phage point, although it's in so many appellate judgments, is just the reminder that the primary function of a first instance judge is to find facts, identify legal points, advance reasons for deciding in sufficient detail to show the parties and this court, if necessary, why they have so decided. They need not, what does Lewis said, be elaborate. And the fourth preliminary point, because it requires some developing, is to consider how in fact this case was run, how in fact it proceeded. So the first point is this criticism was made, I think earlier, of the judge's list of issues as identified at the pre-hearing review, not containing reference effectively to welfare. But if my lords good enough to look at page 29 of the new case management order bundle, paragraph 2, of course, at that stage, the application is adjourned, relisted before this judge, sitting as Deputy High Court Judge, for A and B. And A was a 3-day hearing, and it was the 3-day hearing to determine the factual disputes necessary to enable the court to determine the application. And it's those factual disputes which are then set out in the schedule that we see pages later. And then wholly separately for a 2-day hearing in January. And it's not perhaps particularly solicitors drafting, but presumably final determination we can read as the welfare exercise. Of course, we now know, the judges then know, that the 3-day hearing was going to fall away, which meant that she, the judge, was faced with just the 2-day hearing left in which to try to do everything. And you'll know, because it's referenced in the judgment, that the morning of the first day was largely taken up with the mother's counsel trying to resolve an ethical difficulty, whether she could continue to act. She decided that she could continue to act, but some time was lost doing that. As I understand this, and it's referenced in the judgment, counsel for the mother was then asked to take instructions about exactly which part of the schedule, which had been very recently produced by that stage, the mother wanted to proceed with. And either just before or just after lunch came the exchange, of which there's no transcript, but which we see paraphrased in the judgment, which is everything, please, apart from this bit of it. So by that stage, the judge had lost 3.5 days of 5 days. Now, of course, having limited time wouldn't justify very significant failings, but what then happens, the way in which matters, no doubt fairly briskly were dealt with, have to be seen against the backdrop of having lost all of that time and knowing how difficult it is to find time in the High Court. As it turns out, we know that another day had to be found simply to hear evidence, but submissions had to come in writing, and there wasn't time then for those to be spoken to. 2 points about submissions. The first is that the document my lords have just seen in the supplemental bundle, the closing points, so entitled On Behalf of the Mother, came in at the same time as the father's documents, so they were filed at the same time. So it wasn't a response document, it was a response effectively to how badly the trial must have gone for the mother, because it can't have been a particularly edifying evidential experience if counsel has to start off with the heading inconsistencies when trying to advance a positive case on behalf of the client. The second point arising out of those documents being in writing but not spoken to is if there had been more time, if there had been an oral hearing, then it's entirely possible that some of the wrinkles that we see coming out in the judgment would have been ironed out by the dialectic exercise that takes place between a trial judge who has enough time and counsel when exploring the various issues.
Well, I'm not. There was no pressure of any great sort that one can tell on the 3rd of December. At that stage, I mean, you can come to your response on ground one in due course, but I'm not terribly receptive to the idea that oral closing submissions would have caused a light bulb to have come on that habitual residence has got nothing to do with this.
Very possibly not.
Seeing as everybody thought it had.
Indeed. Indeed. It may help, though, if at this stage I also then take also other documents that help us discern how the trial did proceed and what the issues were. You have at page F6, which is 446 of the 505-page supplemental bundle, the detailed opening submissions on behalf of the father. The first few pages go through what you might expect. My lord, relevant to my lord's point in relation to ground one, the heading, this is page F11, paragraph 25, in relation to the mothers taking the children from Nigeria to England is wrongful removal. But it's then the facts which are largely dealt with underneath that.
Paragraph 24 is the foundational submission.
Yes. But what habitual residence?
Well, I don't want to be critical. This is clearly a very carefully thought about presentation of your client's case by Ms Tabi, but being as critical as we're bound to be on thinking about this, it's not really the point. It's whether it's wrongful removal. I mean, you might describe the wrongful removal clearly a Hague concept. We don't talk about it that way, but it's sort of unfortunate in the context of the argument that is now presented that it should be so described, is it not?
Well, it is, but of course, whilst it's a Hague concept, it's also normal words. The children were removed from the country. It was wrongful according to Nigerian law, and would have been wrongful according to UK law. What other word could be used? It was an reduction within the non-legal, the lay use of the word, but if that term is used, then similar criticism could be made. But perhaps it's not really very much more or less than a shorthand used by lawyers for what I've just said, which is taking the children away from what the judge clearly thought was their home at the time to England. And all the same could be said of then the section dealing with habitual residence at paragraph 33. Save only that, and I'll develop this in due course when I look at the judgment. But whilst 33 talks about rules in relation to the concept of habitual residence, and paragraph 34 talks about the time of their removal, their habitual residence in Nigeria. What then follows, which was and remains the jurisdiction with which they have the greater connection for the following reasons. So I'll say in due course, effectively, home country reasons there.
But can we be clear about your position about this? You know, we've been saying all morning that habitual residence has got nothing to do with this case. Is that right or not?
We will say it hasn't got nothing to do with it. But
We will say
it hasn't got nothing to do with it, but it doesn't assume the pivotal importance from a legal point of view that might.
Why was, I mean, are you going to say that habitual residence is also another way that people talk?
No, I'm going to say that Lord Wilson is right when his lordship says that given the general policy in favour of courts of habitual residence determining children's welfare, is not an irrelevant consideration. It must be open to a father in a non-Hague case to say among the welfare reasons, not directly child focused, but among the welfare reasons why this case should be, these children should be returned to Nigeria, is because, other things being equal, it is in the child's interests for their future to be determined by the courts in which they're habitually resident. We'll say that a wrongful removal case in general, wrongful removal application in general, a summary non-Hague return case in general makes no sense if there is no, I was going to say wrongful, no culpable element in the removal. Because if it is simply, and don't forget, if I may say so, the tension here was between whether the children had lost habitual residence in England, whether they were resident here or in Nigeria. If the judge had accepted that they were still habitually resident here, then it's a mother taking children back home to the country where the courts.
I'm still not understanding what habitual residence has got to do with it.
Well,
I mean, it seems to be absolutely pregnant with possibilities for misunderstanding, for this analysis and so forth, that I mean, the court was not called upon to find out whether the children had been wrongfully removed from England, the country of their habitual residence. It wasn't called upon to find out whether they were still habitually resident in England at the time of their removal from Nigeria. It might have been important to understand, as Mr. Gratian says, the extent of their, how integrated they were in England, having been here for 6 or 7 months. Indeed, but I'm still struggling with the statement that the judge identified, and as I understand you to make, the judge correctly identified the issues.
No, I'm not saying that.
Right. So could we have a, could I get out of your way and you could explain to us what the father's case is in relation to whether there were any errors in the identification of the issues, and if so, what were they?
Well, may I come to that, please?
Yes.
Yes, I will. I wanted just at the moment just to look at what was before the court, and I'm not going to shy away from the fact that legal issues were identified in ways that they oughtn't have been. In due course, I'll say that one can more than glean from the judgment a rationale for making the welfare decisions made, regardless of the way in which of the headings above those analyses. But looking at paragraph 35,
Yes.
then, well, first of all, 34, the rubric I think I was looking at when my lord took me elsewhere. But separately, the second phrase of that sentence makes the point that Nigeria was and remains the jurisdiction with which they have the greater connections for the following reasons. So effectively, home country analysis and rooted in the present, and then all of those reasons we say would perfectly properly be used if looking at home country analysis. And then paragraph 35 even makes it explicitly clear, effectively, the significant overlap between the two, whether one looks to the question of habitual residence or simply to the degree of connection the children have with each jurisdiction, and then in terms, in inverted commas, the home country, it's submitted with the greatest connections and where they were most closely integrated with the
Why, I mean, again, looking at this way of setting the whole thing out, why doesn't one just apply the welfare checklist?
Well,
I mean, what's wrong with the welfare checklist that one can deal with in that with under change of circumstances, with what it means for children to be moved from one place to another and then back again. All this, with great respect, just seems to be cluttering it up.
yes, I don't disagree.
We have to do this when we're applying an international convention, but we don't have to do it when we're applying domestic law.
Well, I don't disagree. Our principal assertion is that having decluttered the judgment and in the knowledge of what was before the court in terms of factual
So your case is that this is about labelling, and that if it's mislabeled, it didn't make any difference to the product in the box.
Indeed.
We have to weigh that, and you're going to explain why you say that.
But whilst I'm still on this document, so
I know that Ms Amritavi is not going to take offence. So it's very easy to be looking at this down the other end of the telescope, and she was doing no more than address the issues that the court had said it was going to address.
Indeed. But addressing, if I may say so, in such a careful and detailed way that we see, for example, under those points A to K, albeit under the habitual residence points, good points referable both to home country, but also to be inputted into the decisions about, as the judge did, and I'll take note of that, about which country they should be in because of their connections there. Then from paragraph 36 onwards, harm to the children if they remain in the UK, so clearly one quarter perhaps of the welfare checklist at that particular factor, change of circumstances, and also to harm, dealt with in detail, reference to the evidence. Paragraph 44 and following, advantages to the children's welfare of a return. So again, firmly rooted, not in a presumption that because removal was wrongful and because habitual residence is an X place, not Y place, then the presumption of return followed, but welfare-based reasons in terms justifying a return. Domestic abuse is dealt with in detail. My learned friend indicated, or criticised the judge for not having considered, for example, the presence or not of a relocation jurisdiction in Nigeria. But whilst you don't, I think, have the experts' report in the bundles, you do have Learned Junior's summary of that at paragraph 53 and following, again in some detail. And at 55B, the expert's explicit confirmation that there is jurisdiction to hear a relocation application, and that that application would be founded on the guiding principle of best interest of the child. And of course, the expert wasn't challenged, it seems, he wasn't called. So again, the judge sets out a summary of the expert's view. If that paragraph is missing, but it probably wasn't contentious. It probably didn't need to be there because the mother's argument wasn't there is their relocation application. But now, of course, the arguments look different. And then, crucially again, because the disadvantage under which my learned friend and his team labour is not having been present at the hearing, you see at paragraph 58 through to 60, that the father's case, at the point of the final hearing, didn't involve Saudi Arabia or Bahrain. It was a single application for the summary of return of the children to Nigeria. Just for completeness, although I won't take my laws through it. You also have the mother's skeleton argument at page 48 and 488, prepared in preparation for that 3-day hearing in January. And at paragraph 9, you will see again a misdescription in relation to the purported centrality of habitual residence. So it's against that backdrop that the judge was considering the case. Lawton, turning to ground one, so habitual residence. I wonder if I could first ask you to look at Baroness Hale at page 100 of the authorities bundle, so Re J, paragraphs 32 and 33. Where we see the introduction of the concept effectively of home country and what can be said about that. And in the knowledge that, of course, this is a judicial gloss effectively rather than reference to any hard letter legal test. But her ladyship says the most one can say in my view is that the judge may find it convenient to start from the proposition.
Sorry, which paragraph you in?
Sorry, paragraph 32.
Thank you. Yep, got it.
the most one can say, in my view, is that the judge may find it convenient to start from the proposition it's likely to be better for a child to return to his home country, for any disputes about his future to be decided there. A case against his doing so has to be made, but the weight to be given to that proposition will vary enormously from case to case. What may be best for him in the long run may be different from what will be best for him in the short run. It shouldn't be assumed in a certain other case allowing a child to remain here while the future is decided inevitably means to remain here forever. And then the variable he refers to from Riel is the degree of connection of the child with each country, not to apply what's become the technical concept of habitual residence, but to ask in a common sense way with which country the child has the closer connection, what's his home country. Factors such as nationality, where he's lived, first language, race, ethnicity, religion, culture, education will come into this, and the length of time is referenced. And of course, this isn't in any sense a test, it's helpful advice from the highest court in the land in relation to what might be helpful when determining these applications. My Lord Justice Jackson's observation to my friend earlier must be true, which is that home country not formally being a recognised legal term may be useful as a concept, but if one tries to treat it as a technical term, difficulties will arise. So, for example, it may well be that one can identify a country with which a child has, for these reasons, greater links, but no home. And the child's home, properly so called, might be in a different country. So the more complicated the family's arrangements, the more international the family, perhaps, the less easily one can simply happen on deciding which is the home country and then what flows from that.
But it appears, I think, I was trying to unpick what the child in J was a child who, even by the time the Supreme Court decided, was only 5 and had been born in the States, lived in Saudi Arabia for the first 2 years, and then come with mother for an intended year in England. The issue was whether the child should go back to Saudi Arabia where the father had remained.
Yes.
The marriage having failed while the mother was in England.
Yes.
So you there have got a child who was born for 2 years in Saudi Arabia and then effectively a year in England before a dispute then arose. And so the concept of home had to be considered against that background. So
yes.
It all depends.
Indeed, and the children in this case have a similarly complicated background. And if the judge is right, as we say she must have been, in identifying that leaving England was deliberate, definite, final, the consequences of which being there was no home, there was no school, there was no geographical location, then concepts such as length of time and where lived most of life, etc., have rather less relevance, or at least if they have relevance to deciding which the home country is, the home country itself has rather less relevance. My lords, would that be a convenient place for me to break?
Yes. Now, just it would help us for reasons quite unrelated to the case, just to know what sort of amount of time do you think you're likely to take?
I would hope to be finished comfortably in an hour and a half.
Well, would it be inconvenient to the parties if we began, say, at 1:45? Would that be inconvenient to you? Does that cause anybody any difficulty?
No.
Right, is that possible? All right, well, we'll resume again at 1:45.
Short hours.